FERA, Foreign Exchange Regulation Act 1973. FERA, Foreign Exchange Regulation Act 1973, FAQ Section 1. 1. What is FERA? 1973. FERA stands for Foreign Exchange Regulation Act 1973. It was an Indian law enacted to regulate foreign exchange transactions, conserve foreign exchange resources, and control activities related to foreign exchange and foreign securities. 2. When did FERA come into force? FERA came into force on 1st January 1974. 3. What was the main objective of FERA? The main objectives of FERA were conservation of foreign exchange, regulation of payments and dealings in foreign exchange, control of external trade and payments, restriction on activities that could adversely affect India's foreign exchange reserves. 4. To whom did FERA apply? FERA applied to all citizens of India, companies registered in India, foreign nationals and companies operating in India, Indian citizens and companies outside India, in certain cases. 5. Which authority administered FERA? FERA was primarily administered by the Enforcement Directorate, ED, under the Ministry of Finance, Government of India. 6. Was FERA a civil law or criminal law? FERA was a criminal law. Violations were treated as criminal offences. Presumption of guilt was on the accused. Severe penalties, including imprisonment, were prescribed. 7. What types of transactions were regulated under FERA? FERA regulated foreign exchange transactions, import and export of currency, acquisition and holding of foreign securities, foreign direct investment, FDI, payments to and from non-residents. 8. What were authorized dealers under FERA? Authorized dealers were banks or financial institutions permitted by the Reserve Bank of India, RBI, to deal in foreign exchange under FERA. 9. What were the penalties under FERA? Penalties under FERA included heavy monetary fines, confiscation of property, imprisonment for serious offences. 10. Is FERA still in force today? No. FERA has been repealed and replaced by Foreign Exchange Management Act 1999, FEMA, with effect from 1st June 2000. 11. What happened to cases initiated under FERA after repeal? Pending investigations and prosecutions under FERA continued. Offences committed during the FERA period are still punishable under FERA provisions. 12. What is the major difference between FERA and FEMA? FERA, FEMA, criminal law, civil law, strict controls, liberalized framework, presumption of guilt, presumption of innocence, focus on regulation, focus on management. FERA, Foreign Exchange Regulation Act 1973, FAQ Section 2. 13. What was the role of the Reserve Bank of India, RBI, under FERA? Under FERA, the Reserve Bank of India, RBI, had wide powers to grant or refuse permission for foreign exchange transactions, regulate foreign investments, authorize dealers to deal in foreign exchange, monitor payments to and from non-residents. 14. What was meant by foreign exchange under FERA? Foreign exchange included foreign currency, deposits, credits, and balances payable in foreign currency, drafts, travelers' checks, letters of credit expressed in foreign currency. 15. What were foreign securities under FERA? Foreign securities meant shares, bonds, debentures, or other securities issued by a foreign entity, denominated in foreign currency or payable outside India. 16. Could Indian residents hold foreign assets under FERA? Generally, no. Indian residents were not allowed to hold foreign assets or foreign currency without RBI permission. Strict disclosure and approval requirements applied. 17. What restrictions existed on export and import of currency? FERA imposed strict limits on taking Indian currency or foreign currency outside India. Mandatory declaration of currency at customs. RBI approval for higher amounts. 18. Were foreign companies allowed to operate in India under FERA? Yes, but with severe restrictions such as limits on shareholding, mandatory dilution of foreign equity, restrictions on repatriation of profits. 19. What was Section 9 of FERA related to? Section 9 dealt with restrictions on payments to non-residents, foreign companies, foreign bank accounts, without prior RBI permission. 20. What powers did Enforcement Directorate, ED, have under FERA? ED officers could search and seize documents, arrest persons without warrant, conduct investigations, launch prosecutions in court. 21. Was compounding of offences allowed under FERA? Initially, no. FERA offences were criminal in nature, but later amendments allowed limited compounding of certain offences. 22. What was the burden of proof under FERA? The burden of proof was on the accused, not on the prosecution. This made FERA one of the strictest economic laws in India. 23. Did FERA apply to NRIs, non-resident Indians? Yes. NRIs were subject to FERA provisions regarding property, investments, and bank accounts in India. 24. Why was FERA replaced by FEMA? FERA was replaced because India adopted economic liberalization in 1991. Strict criminal provisions were unsuitable for a growing economy. A management-based law, FEMA, was more appropriate. 25. Is knowledge of FERA still important today? Yes, because old cases are still pending. Questions are frequently asked in UPSC, SSC, banking, and law exams. It helps understand the evolution of India's foreign exchange laws. 26. What was meant by person resident in India under FERA? A person resident in India meant a person who ordinarily resided in India, except those staying abroad for employment, business, or any other purpose indicating intention to stay outside India for an uncertain period. 27. What were the restrictions on acquisition of immovable property under FERA? Non-residents required prior RBI permission to acquire immovable property in India. Indian residents needed RBI approval to acquire property outside India. 28. What was Section 29 of FERA related to? Section 29 dealt with restrictions on establishment of place of business in India by foreign companies, including prior RBI approval, restrictions on foreign shareholding, conditions on continuation of business. 29. What was Section 19 of FERA about? Section 19 imposed restrictions on import and export of currency, taking Indian or foreign currency outside India, bringing foreign currency into India without declaration. 30. What was Section 8 of FERA concerned with? Section 8 prohibited dealings in foreign exchange, payments to non-residents, without general or special permission of the RBI. 31. Could enforcement officers arrest without warrant under FERA? Yes. Enforcement Directorate officers had power to arrest without warrant for FERA offences. Such power reflected the criminal nature of the act. 32. What was the punishment for continuing offences under FERA? Additional fine for every day during which the offence continued. In serious cases, imprisonment could also be imposed. 33. Were company directors liable under FERA? Yes. Directors, managers, and officers in charge of the company could be held personally liable if the offence was committed with their consent or neglect. 34. What was meant by repatriation of foreign exchange? Repatriation meant bringing foreign exchange earned abroad back into India within the prescribed time. Failure to repatriate was an offence under FERA. 35. What was Section 18 of FERA related to? Section 18 dealt with export of goods, requiring declaration of full export value, realization and repatriation of export proceeds to India. 36. Were appeals allowed under FERA? Yes. Appeals could be filed before the appellate board. Further appeal lay before the High Court on questions of law. 37. Did FERA override other laws? Yes. Provisions of FERA had overriding effect. In case of conflict, FERA prevailed over other laws. 38. What happened to FERA penalties after FEMA came into force? Offences committed during the FERA period remained punishable. Proceedings continued as if FERA had not been repealed. New violations were governed by Foreign Exchange Management Act 1999. 39. Why is FERA considered a draconian law? Because presumption of guilt, stringent restrictions, severe punishments, extensive powers to enforcement agencies. 40. Is FERA relevant for exams today? Yes. FERA is highly relevant for UPSC, SSC, banking, judiciary, and law entrance exams. Understanding the shift from control-based to management-based forex regulation. 41. What was the meaning of authorization under FERA? Authorization meant permission granted by the Reserve Bank of India, RBI, to a person or institution to deal in foreign exchange, foreign securities, or specified transactions under FERA. 42. What was the concept of general permission under FERA? General permission was a blanket approval issued by RBI allowing certain classes of transactions without seeking individual permission each time, subject to prescribed conditions. 43. What was meant by special permission? Special permission referred to case-specific approval granted by RBI for transactions not covered under general permission. 44. Were gifts in foreign currency allowed under FERA? Generally restricted. Allowed only with prior RBI approval. Strict limits and conditions applied. 45. Could Indian residents open foreign bank accounts under FERA? No, unless prior RBI permission was obtained. Otherwise, opening or maintaining foreign bank accounts was a criminal offence. 46. What were the restrictions on borrowing or lending in foreign exchange? Borrowing or lending foreign exchange without RBI approval was prohibited. Even transactions between residents and non-residents required prior permission. 47. What powers did customs authorities have under FERA? Customs authorities could check declarations of currency, seize undeclared or excess foreign exchange, coordinate with Enforcement Directorate in investigations. 48. Could prosecution be launched without sanction under FERA? No. Prior sanction of the central government or authorized officer was required. This acted as a procedural safeguard. 49. What was the limitation period for prosecution under FERA? No specific limitation period was prescribed. Serious offences could be prosecuted even after a long delay. 50. What was the role of adjudication under FERA? Adjudicating officers decided cases of contravention. They could impose penalties, fines, and confiscation. Proceedings were quasi-judicial in nature. 51. Could penalties be imposed without criminal trial under FERA? Yes. Adjudication proceedings were separate from criminal prosecution. Both could proceed simultaneously. 52. What was meant by mens rea under FERA? Mens rea, criminal intent, was not always required. Mere contravention of provisions could result in liability. 53. Were compounding fees refundable under FERA? No. Once compounded, the fee paid was non-refundable. Compounding closed the matter permanently. 54. How are search and seizure powers exercised under FERA? Enforcement officers could conduct searches based on reasonable belief. Seized documents and assets could be retained for investigation. 55. What was the impact of FERA on India's economy? Helped conserve scarce foreign exchange in early decades, but also discouraged foreign investment and liberal trade. Eventually replaced due to economic liberalization. 56. How did FERA differ in philosophy from FEMA? FERA focused on regulation and control. FEMA focuses on management and facilitation of foreign exchange. FERA treated violations as crimes. FEMA treats them mainly as civil contraventions under Foreign Exchange Management Act 1999. 57. Is FERA completely obsolete today? No. Though repealed, FERA continues to apply to past violations. Courts still deal with pending FERA matters. 58. Why should law and competitive exam students study FERA? Because it explains India's forex control history, helps understand FEMA, PMLA, and ED powers, is frequently tested in exams. 59. What was the meaning of contravention under FERA? Contravention meant any act or omission that violated the provisions of FERA, RBI directions, or conditions of permission granted under the Act. 60. Could ignorance of law be a defense under FERA? No. Ignorance of law was not a valid defense. Even unintentional violations could attract liability. 61. What was the role of statements recorded under FERA? Statements recorded by Enforcement Directorate officers were admissible as evidence. Such statements did not require presence of a magistrate. 62. Could a person be compelled to give information under FERA? Yes. Persons were legally bound to provide documents and information. Failure to comply could itself amount to an offence. 63. What safeguards were available to accused persons under FERA? Limited safeguards, such as requirement of sanction before prosecution, right to appeal against adjudication orders. However, overall safeguards were weaker compared to modern laws. 64. Could FERA proceedings and criminal prosecution run together? Yes. Adjudication proceedings and criminal trials were independent. Both could continue simultaneously for the same offence. 65. What was the role of high courts under FERA? High courts heard appeals on questions of law. They also exercised writ jurisdiction in exceptional cases. 66. Could penalties be recovered as arrears of land revenue? Yes. Monetary penalties imposed under FERA could be recovered as arrears of land revenue. 67. What happened if penalty was not paid under FERA? Property could be attached. Imprisonment could be ordered in default of payment. 68. Did FERA apply to trusts and associations? Yes. Trusts, societies, and associations of persons were covered. Office bearers could be held personally liable. 69. What was the effect of repeal of FERA on investigations? Ongoing investigations continued under FERA. Repeal did not provide immunity for past acts. 70. How did courts view FERA offences? Courts treated FERA offences as serious economic offences affecting national economic interest. 71. Could settlement be reopened after compounding under FERA? No. Once an offence was compounded, the matter attained finality. 72. What was the maximum punishment under FERA? Heavy monetary penalty, often linked to the amount involved. Imprisonment up to 7 years in serious cases. 73. Did FERA recognize the concept of reasonable cause? Limited recognition. Strict liability dominated most offences. 74. How is FERA different from modern economic laws? Highly restrictive and control-oriented. Criminalization of most violations. Modern laws like Foreign Exchange Management Act, 1999 prefer civil penalties and compliance. 75. What is the overall legacy of FERA? FERA laid the foundation for India's foreign exchange control regime, evolution towards liberalized and facilitative laws, understanding enforcement powers of economic regulators. FERA, Foreign Exchange Regulation Act 1973, FAQ Section 6. 76. What was the meaning of foreign company under FERA? A foreign company meant a company incorporated outside India, or a company incorporated in India in which non-residents held substantial interest as defined under FERA and RBI guidelines. 77. What restrictions were imposed on shareholding of foreign companies? Foreign companies were required to reduce foreign equity, generally to 40%. RBI approval was mandatory for continuation of higher foreign shareholding. Non-compliance could lead to closure of business. 78. What was Section 31 of FERA related to? Section 31 imposed restrictions on acquisition, holding, and transfer of immovable property in India by non-residents except with prior RBI permission. 79. Could Indian companies issue shares to non-residents under FERA? Yes, but only with prior RBI approval, subject to strict conditions regarding pricing, sector, and repatriation. 80. What was meant by export proceeds under FERA? Export proceeds referred to sale consideration received from export of goods or services, required to be realized and repatriated to India within the prescribed time. 81. What action could be taken for non-realization of export proceeds? Adjudication proceedings could be initiated. Penalties and prosecution could follow. Burden of proof lay on the exporter. 82. What was the significance of declarations under FERA? Declarations were mandatory for imports, exports, and currency movement. False or incomplete declarations constituted a serious offense. 83. What was the role of adjudicating authority under FERA? To inquire into contraventions, to impose penalties and order confiscation, to pass reasoned orders after giving opportunity of hearing. 84. Could confiscated property be released under FERA? Yes. Confiscated property could be released on payment of redemption fine at the discretion of the authority. 85. What was the scope of vicarious liability under FERA? Persons in charge of company affairs were deemed guilty, unless they proved lack of knowledge or due diligence. 86. Were offences under FERA compoundable at all stages? Only specified offences could be compounded. Serious and willful violations were generally not compoundable. 87. Did FERA recognize economic offences as offences against the state? Yes. Courts consistently held FERA violations to be economic offences affecting national interest. 88. Could summons be issued under FERA? Yes. Enforcement officers could issue summons. Attendance and production of documents was mandatory. 89. What happened if a person failed to comply with summons? Failure amounted to an offense. Penal consequences could follow. 90. How are appeals against adjudication orders handled? First appeal lay before the appellate board. Further appeal lay before the High Court on questions of law. 91. Did repeal of FERA create any new rights for offenders? No. Repeal did not absolve liability. Rights and liabilities remained intact for past acts. 92. How does FERA influence interpretation of FEMA today? Courts use FERA to understand legislative intent. Helps interpret strict versus liberal provisions under Foreign Exchange Management Act 1999. 93. Why was FERA enforcement considered harsh? Because of criminal prosecution, presumption of guilt, wide search, seizure, and arrest powers. 94. Is knowledge of FERA useful for current legal practice? Yes. Many legacy cases are still pending, relevant for ED matters, appeals, and constitutional challenges. 95. What should students remember most about FERA for exams? Criminal law nature, presumption of guilt, RBI's central role, replacement by FEMA in 2000. FERA, Foreign Exchange Regulation Act 1973, FAQ Section 7. 96. What was the concept of reasonable belief under FERA? Reasonable belief allowed enforcement officers to act, search, seizure, arrest when they had objective grounds based on material available to believe a contravention had occurred. 97. Could evidence seized under FERA be used in other proceedings? Yes. Lawfully seized documents material could be used in adjudication and prosecution. Courts generally upheld such use if procedures were followed. 98. Were FERA offences cognizable and non-bailable? Serious FERA offences were treated as cognizable. Bail was restricted due to the economic offence nature. 99. What protection was available to officers acting under FERA? Actions taken in good faith under FERA were protected. Officers were shielded from personal liability for lawful acts. 100. Could partners of a firm be held liable under FERA? Yes. Partners in charge of and responsible for business conduct could be held vicariously liable unless they prove due diligence. 101. What was the standard of proof in FERA adjudication? Preponderance of probability, quasi-judicial, distinct from the higher criminal trial standard. 102. Did FERA permit retrospective application? No. Penal provisions were not retrospective. Only acts committed during FERA's operation were punishable. 103. Could parallel action be taken under customs or IPC? Yes. FERA action could proceed alongside Customs Act or IPC proceedings, subject to legal safeguards against double punishment. 104. How are repeat offenders treated under FERA? Enhanced penalties. greater likelihood of prosecution and imprisonment. 105. Could courts quash FERA proceedings? Yes, in limited cases. Lack of jurisdiction, abuse of process, violation of fundamental rights. 106. What was the relevance of RBI circulars under FERA? RBI circulars had binding force. Non-compliance amounted to contravention of FERA. 107. Did FERA recognize compulsion or coercion as a defense? Very limited recognition. Generally, strict liability prevailed. 108. How are fines quantified under FERA? Often linked to the amount involved in the contravention. Additional daily fines for continuing offences. 109. What lessons did policymakers draw from FERA? Excessive control hampers growth. Need for compliance-oriented regulation. Shift from criminalization to civil penalties. 110. What finally replaced FERA's regulatory philosophy? India adopted a management-based framework under Foreign Exchange Management Act 1999, effective 1st June 2000, emphasizing facilitation over control. FERA, Foreign Exchange Regulation Act 1973, FAQ Section 8. 111. What was the role of mens rea in criminal prosecution under FERA? Under FERA, mens rea, intention, was not essential for many offences. Mere contravention of statutory provisions was sufficient to attract liability, reflecting the Act's strict liability framework. 112. Could voluntary disclosure reduce liability under FERA? Voluntary disclosure did not automatically absolve liability. However, it could be considered for leniency in penalty or compounding where permitted. 113. Were technical or procedural violations treated lightly under FERA? No. Even technical breaches were treated seriously. The Act emphasized strict compliance over intent. 114. What was the evidentiary value of confessions under FERA? Confessions made to Enforcement Directorate officers were admissible, unless proven to be obtained by coercion or threat. 115. Could summons under FERA be challenged? Yes, but only on limited grounds such as lack of jurisdiction, mala fide exercise of power. Routine challenges were generally discouraged by courts. 116. Did FERA allow plea bargaining? No formal system of plea bargaining existed. Only compounding of specified offences was available. Criminal prosecution otherwise proceeded normally. 117. What was the treatment of benami or proxy transactions under FERA? Benami arrangements to hold foreign exchange or assets were prohibited. Real beneficiaries could be prosecuted despite use of proxies. 118. How did FERA deal with hawala transactions? Hawala transactions were strictly prohibited, treated as serious economic offences affecting national interest. 119. Could foreign exchange seized under FERA be returned? Yes, but only after completion of proceedings or on payment of redemption fine if permitted. 120. What was the relevance of economic sovereignty in FERA cases? Courts often emphasize that FERA protected economic sovereignty of India. Violations were not merely private wrongs but public offences. 121. Could constitutional remedies be invoked against FERA actions? Yes. Writ petitions under Articles 26 and 32 were maintainable. But courts exercised judicial restraint due to economic offence nature. 122. Did FERA recognize limitation for adjudication proceedings? No specific statutory limitation was prescribed. Proceedings could continue after long periods, subject to fairness. 123. How are seized documents preserved under FERA? Documents were retained as per statutory procedure, required for adjudication, prosecution, or appeals. 124. What happened if a person died during FERA proceedings? Criminal prosecution abated. Adjudication relating to penalty could continue against the estate, as per law. 125. What is the present-day relevance of FERA jurisprudence? FERA case law remains relevant to interpret legacy disputes, understand enforcement powers, contrast with the liberal regime under Foreign Exchange Management Act 1999, FERA, Foreign Exchange Regulation Act 1973, FAQ Section 9. 126. What was the treatment of offences involving large foreign exchange amounts under FERA? Considered aggravated economic offences. Attracted higher penalties and imprisonment. Courts adopted a strict approach in sentencing. 127. Could simultaneous adjudication and prosecution amount to double jeopardy? No. Adjudication, civil quasi-judicial, and prosecution, criminal, were distinct. Hence, no violation of Article 22 of the Constitution. 128. What role did intention play in penalty determination under FERA? Intention was generally irrelevant for liability. However, it could influence quantum of penalty in adjudication. 129. Could foreign exchange violations be regularized retrospectively? Generally not permitted. Post facto approvals were rarely granted and only in exceptional cases. 130. What was the significance of RBI permission conditions under FERA? Conditions attached to RBI permissions were binding. Breach of conditions amounted to a separate contravention. 131. Were offences under FERA compoundable after prosecution began? In limited cases, yes. Subject to approval of competent authority and payment of compounding amount. 132. What was the treatment of unaccounted foreign exchange under FERA? Presumed to be held illegally. Subject to seizure, confiscation, and prosecution. 133. How are exporters monitored under FERA? Mandatory declarations. Bank reporting requirements. RBI and its scrutiny for realization of export proceeds. 134. Could statements under FERA be retracted? Yes, but retraction had to be prompt and credible. Courts examined voluntariness and surrounding circumstances. 135. What was the impact of delay in FERA proceedings? Mere delay did not invalidate proceedings. However, inordinate and unexplained delay could invite judicial scrutiny. 136. Did FERA recognize corporate criminal liability? Yes. Companies could be prosecuted, along with persons responsible for management. 137. What happened to seized assets if the accused was acquitted? Assets were liable to be returned, subject to appeal rights of the department. 138. Could penalty orders be stayed during appeal? Yes. Appellate authorities could grant stay of recovery, often subject to deposit of part penalty. 139. How did FERA influence later economic legislation? FERA laid the groundwork for strong enforcement mechanisms, later balanced by liberalization under Foreign Exchange Management Act 1999. 140. What is the key takeaway from FERA for exam purposes? Criminal, control-based law. Presumption of guilt. Wide powers to ED and RBI. Replaced by management-based FEMA regime. FERA, Foreign Exchange Regulation Act 1973, FAQ Section 10. 141. What was the scope of judicial review in FERA matters? Courts exercised limited judicial review. Interference was generally restricted to cases of lack of jurisdiction, violation of natural justice, or malafides. 142. Could procedural irregularities invalidate FERA proceedings? Minor procedural lapses did not vitiate proceedings. Only serious violations affecting fairness could invalidate action. 143. What was the evidentiary value of bank records under FERA? Bank records and reports were treated as reliable documentary evidence. Non-cooperation by banks could invite regulatory action. 144. Did FERA recognize the concept of continuing offense? Yes. Certain contraventions were treated as continuing offenses. Additional penalties accrued for each day of continuation. 145. Could foreign exchange offenses be settled through consent orders? No formal consent order mechanism existed. Only statutory compounding, where allowed, could close proceedings. 146. What was the relevance of intent in sentencing under FERA? While intent was not essential for liability, it could be considered as a mitigating or aggravating factor in sentencing. 147. Were intermediaries and agents liable under FERA? Yes. Agents, brokers, or facilitators who aided contraventions could be prosecuted as abettors. 148. How are foreign remittances monitored under FERA? Through authorized dealers, banks, mandatory reporting to RBI, and scrutiny in suspicious cases. 149. What happened to penalties imposed but not recovered at repeal? Recovery proceedings continued after repeal. Repeal did not extinguish government dues. 150. Did FERA allow delegation of powers? Yes. Central government and RBI could delegate powers. Delegation had to be express and lawful. 151. What was the role of notifications under FERA? Notifications clarified, restricted, or permitted transactions. They had statutory force when issued under the Act. 152. Could FERA provisions override contractual terms? Yes. Any contract inconsistent with FERA was void to that extent. 153. How are repeat defaults treated at the adjudication stage? Past conduct was considered. Higher penalties were generally imposed on repeat violators. 154. What was the transitional arrangement from FERA to FEMA? FERA was repealed with savings clauses. Pending matters continued under FERA. New transactions were governed by Foreign Exchange Management Act 1999. 155. What is the final exam-oriented summary of FERA? Enacted 1973. In force 1974 से 2000. Nature: criminal, control-oriented. Key authorities: RBI Enforcement Directorate. Core features: presumption of guilt, strict compliance. Status: repealed, but legacy cases continue. FERA, Foreign Exchange Regulation Act 1973, FAQ Section 11, Final Wrap-Up Quick Revision. 156. What was the constitutional validity of FERA? FERA was upheld as constitutionally valid by courts, recognizing Parliament's power to enact stringent economic laws in the national interest. 157. How did courts balance individual rights with FERA enforcement? Courts generally gave priority to economic security of the nation, intervened only where there was clear abuse of power or violation of natural justice. 158. What was the role of saving clause after repeal of FERA? The saving clause ensured that past acts remained punishable. Pending investigations, adjudications, and prosecutions continued under FERA. 159. Did FERA influence bail jurisprudence in economic offences? Yes. Courts treated FERA offences as serious economic crimes. Bail was granted cautiously, considering gravity and public interest. 160. Could FERA penalties be challenged as excessive? Yes, but courts rarely interfered. Penalties were reduced only if found arbitrary or disproportionate. 161. What compliance lesson does FERA offer to businesses? Strict adherence to regulatory permissions is critical. Documentation and timely reporting are essential. Non-compliance can have long-term legal consequences. 162. How is FERA relevant for present-day ed investigations? Many legacy cases are still pending. FERA jurisprudence guides interpretation of enforcement powers. 163. What is the most important difference students must remember between FERA and FEMA? FERA, criminal, control-based, presumption of guilt. FEMA, civil, management-based, presumption of innocence under Foreign Exchange Management Act 1999. 164. What are the top 5 exam keywords associated with FERA? Presumption of guilt, criminal liability, RBI permission, enforcement directorate powers, repeal with savings clause. 165. What is the one-line legacy of FERA? FERA represents India's era of strict foreign exchange control, which later evolved into a liberal, compliance-oriented regime under FEMA. FERA, Foreign Exchange Regulation Act 1973, FAQ Section 12. 166. What is the single biggest criticism of FERA? FERA was criticized for being overly harsh and control-oriented, discouraging foreign investment and ease of doing business due to criminalization of routine forex violations. 167. Why was presumption of guilt included in FERA? Because foreign exchange was considered scarce and vital. Parliament believed strict liability was necessary to protect economic sovereignty. 168. How did FERA affect India's foreign investment climate? Created uncertainty for foreign investors. Led to exit or downsizing of many multinational companies. Prompted policy rethink post ek non-law ek liberalization. 169. What was the most litigated issue under FERA? Realization and repatriation of export proceeds. RBI permissions and their alleged violations. Search, seizure, and arrest powers of ed. 170. Did FERA allow proportionality in punishment? Limited scope. Courts generally deferred to legislative intent. Proportionality evolved more clearly under later laws. 171. What compliance principle emerged from FERA jurisprudence? Permission first, transaction later. Any forex transaction without RBI permission was presumed illegal. 172. How does FERA help understand FEMA today? FERA serves as a contrast law, helping students and practitioners appreciate. Shift from control management. Criminal civil liability. Enforcement facilitation under Foreign Exchange Management Act 1999. 173. What was FERA's impact on economic offense jurisprudence? Strengthened concept of economic crimes against the state. Influenced later statutes like PMLA and customs law enforcement. 174. What is the most important date to remember for exams? 1st June 2000 FEMA came into force, FERA repealed with savings clause. 175. What is the final three-line exam summary of FERA? Enacted in 1973 to conserve foreign exchange. Criminal, strict, permission-based regime. Replaced by FEMA due to economic liberalization. 176. One-word memory triggers for FERA. Control, criminal, permission, presumption, enforcement. 177. How should students revise FERA in 10 minutes before exam? Nature, criminal law. Core authority, RBI plus ED. Key features, presumption of guilt, strict compliance. Repeal, replaced by FEMA, 2000. Legacy, pending cases continue. 178. What is the final legal legacy of FERA? FERA marks India's pre-liberalization economic philosophy, forming the foundation upon which modern foreign exchange management law was built. 179. Did courts accept strict liability under FERA without intent? Yes, courts consistently upheld strict liability, holding that mens rea was not essential for most contraventions under FERA. 180. How did courts treat technical violations under FERA? Even technical or procedural lapses were punishable. However, quantum of penalty could be moderated in deserving cases. 181. Could RBI permissions be implied or must they be explicit? RBI permissions had to be explicit and specific. Implied permission was generally not recognized. 182. What was the legal effect of violating RBI directions or circulars? RBI directions had statutory force. Violation amounted to contravention of FERA itself. 183. Were statements recorded by ED officers considered confessions? Yes. Statements recorded under statutory powers were admissible, unless proved to be obtained by coercion or threat. 184. How did courts view delay by ED in initiating proceedings? Delay alone did not invalidate proceedings. Prejudice caused by inordinate delay could justify judicial relief. 185. Could multiple penalties be imposed for the same transaction? Yes. Where? Multiple statutory provisions were violated, provided it did not amount to double punishment for the same offense. 186. What was the approach to burden of proof under FERA? Initial burden on prosecution had to show contravention. Thereafter, burden shifted to the accused to prove legality. 187. Could foreign nationals be prosecuted after leaving India? Yes. FERA had extraterritorial application in specified cases. Proceedings could continue even if the accused left India. 188. How are shell companies or dummy entities treated under FERA? Substance over form approach. Real controllers and beneficiaries were held liable. 189. Could confiscation be ordered without conviction? Yes. Confiscation could be ordered in adjudication proceedings, independent of criminal prosecution outcome. 190. What was the judicial stance on compounding under FERA? Compounding was treated as a statutory concession. No vested right to compounding existed. 191. How did FERA influence later enforcement philosophy? FERA established strong investigative powers, concept of economic offences as public wrongs, later softened under Foreign Exchange Management Act 1999. 192. What caution did courts give to enforcement agencies under FERA? Powers must be exercised fairly and proportionately. Abuse of power could invite constitutional scrutiny. 193. Did acquittal in criminal case automatically nullify adjudication penalty? No. Criminal trial and adjudication were independent. Acquittal did not automatically cancel penalty orders. 194. How did courts interpret reasonable opportunity of hearing? Mandatory before adjudication. Includes notice, access to material, and chance to respond. 195. What is the final advance takeaway for exams and practice? FERA strict, criminal, control-based regime. Heavy reliance on RBI permission-led enforcement. Replaced by liberal, civil framework under FEMA, but legacy cases endure. 196. Is every foreign exchange transaction illegal under FERA unless permitted? Yes. General rule. All foreign exchange transactions were prohibited unless permitted. Permission could be general or special from RBI. 197. Can RBI permission cure an offence committed earlier? Generally no. Post facto permission was exceptional. Earlier contravention normally remained punishable. 198. Is violation of RBI permission conditions a minor offence? No. Breach of any condition was treated as a separate contravention, often tested as a trick MCQ. 199. Does repeal of FERA mean automatic application of FEMA benefits? No. FERA violations are judged only under FERA. Liberal provisions of Foreign Exchange Management Act 1999 do not apply retrospectively. 200. Can mens rea be completely ignored in all FERA cases? For liability, mostly yes. For quantum of punishment, courts may consider conduct. 201. Is it required to prove loss of foreign exchange to India? No. Actual loss is irrelevant. Mere contravention of statutory provisions is sufficient. 202. Does permission under FERA include silence by RBI? No. Silence consent. Permission must be clear, express, and provable. 203. Can a person rely on bank advice as a defense? No absolute defense. Banks act as authorized dealers. Ultimate responsibility remains with the person. 204. Are FERA offences compoundable as a matter of right? No. Compounding is discretionary, not a vested right. 205. Can technical lapse plus no mens rea acquittal? Usually no. FERA follows strict compliance. This is a common examiner trap. 206. Is adjudication under FERA equivalent to civil penalty only? No. Adjudication is quasi-judicial. Criminal prosecution may still follow. 207. Can it reopen a case already adjudicated? Yes, for criminal prosecution, provided legal requirements are met. 208. Does cooperation with it guarantee immunity? No. Cooperation may help in leniency. It does not erase liability. 209. Can penalty exceed the amount involved? Yes. Penalties could be multiple times the amount involved. 210. What is the examiner's favorite one-line FERA principle? Under FERA, everything is prohibited unless permitted. FERA, Foreign Exchange Regulation Act 1973, FAQ Section 15. 211. Is FERA permission transaction-specific or person-specific? Transaction-specific unless expressly stated otherwise. Using permission beyond its scope contravention. 212. Can substantial compliance save an accused under FERA? No. FERA required strict and literal compliance. Substantial compliance doctrine was generally rejected. 213. Does later liberalization policy help in deciding FERA cases? No. Cases are decided as per law in force at the time of offense. Later liberal policies are irrelevant. 214. Is FERA a complete code by itself? Yes. FERA was treated as a self-contained code. Its procedures and penalties operated independently. 215. Can benefit of doubt be freely granted in FERA cases? No. Given presumption of guilt. Benefit of doubt was narrowly applied. 216. Does RBI approval after detection wipe out criminal liability? No. Subsequent approval does not nullify offense already committed. 217. Is mens rea totally irrelevant under FERA? For establishing offense, mostly irrelevant. For sentencing, penalty discretion may be relevant. 218. Are FERA offenses economic offenses or regulatory offenses? Courts classify them as serious economic offenses affecting national interest. 219. Can an accused challenge RBI policy under FERA proceedings? No. RBI policy decisions were not justiciable in adjudication. Only legality, not wisdom, could be examined. 220. Is prosecution mandatory after adjudication? No. Adjudication and prosecution are independent. Prosecution depends on gravity and government sanction. 221. Can penalty be imposed even if transaction caused no loss? Yes. Loss is irrelevant. Contravention itself attracts penalty. 222. Does cooperation during investigation guarantee compounding? No. Compounding is purely discretionary. 223. Is FERA considered a beneficial legislation? No. It is a penal and restrictive statute, hence interpreted strictly. 224. Can a person be punished twice under FERA? No double punishment for same offense. But adjudication plus prosecution is permissible. 225. What is the final golden rule to answer FERA MCQs? Assume prohibition first, permission later. FERA, Foreign Exchange Regulation Act 1973, FAQ Section 16. 227. Does hardship or bona fide belief excuse violation under FERA? No. Hardship or bona fide belief is not a defense. At best, it may be considered only for leniency in penalty. 228. Can RBI grant relaxation contrary to FERA provisions? No. RBI acts within the four corners of FERA. It cannot override statutory prohibitions by policy alone. 229. Are FERA provisions interpreted strictly or liberally? Strict interpretation being penal in nature, but object-oriented interpretation adopted to protect foreign exchange. 230. Can foreign exchange offenses be treated as private disputes? No. Courts consistently held FERA violations as offences against the state. Public interest overrides private settlement. 231. Is mens rea presumed against the accused under FERA? Effectively, yes. Law presumes culpability once contravention is shown. Accused must rebut presumption. 232. Can reliance on professional advice, CA advocate, be a defense? No complete defense. Professional advice does not override statutory obligation. Responsibility remains with the person entity. 233. Does FERA recognize the doctrine of proportionality? Very limited application. Courts generally deferred to legislative policy of deterrence. 234. Can ED initiate action solely on suspicion? No. Must be based on reasonable belief supported by material. Pure conjecture is not sufficient. 235. Are RBI circulars subordinate legislation under FERA? Yes. RBI circulars directions issued under FERA have binding statutory force. 236. Can foreign exchange once confiscated vest permanently in government? Yes. Upon finality of proceedings. Subject to appeal outcomes. 237. Does acquittal in Customs Act case automatically help in FERA case? No. Proceedings under Customs and FERA are independent. One does not automatically nullify the other. 238. Can FERA proceedings survive even after long lapse of time? Yes. No statutory limitation. Only unfair prejudice due to delay may invite relief. 239. What is the most dangerous assumption students make about FERA? Assuming it behaves like FEMA. 240. What is the single safest answer approach in FERA MCQs? When in doubt, choose the option that is more restrictive, more prosecution friendly, less liberal. 241. Can benefit of subsequent compliance be claimed? No. Subsequent compliance does not erase past offense. 242. Does repeal of FERA dilute seriousness of offences? No. Courts treat legacy offences with same gravity. 243. What is the last mile difference between FERA and FEMA to remember? FERA, crime punishment deterrence. FEMA, contravention penalty compliance under Foreign Exchange Management Act 1999. 244. What is the examiner's ultimate trap question on FERA? Since FEMA is liberal, old FERA cases should also be treated liberally. 245. One-line ultra-final takeaway of FERA. FERA criminalized foreign exchange control to protect India's economic sovereignty, and its shadow continues through saved liabilities even today. FERA, Foreign Exchange Regulation Act 1973, FAQ Section 17. 246. Can equity or fairness override clear FERA provisions? No. Equity has no place against explicit statutory prohibition. Courts enforced FERA as written, not on sympathetic grounds. 247. Is no malified intention a valid defense under FERA? No. Absence of malified does not negate contravention. It may only influence quantum of penalty. 248. Can ED choose adjudication first or prosecution first? Yes. ED has discretion. Either can be initiated independently, subject to sanction. 249. Does FERA recognize waiver of statutory violations? No. Statutory violations cannot be waived by conduct, consent, or delay. 250. Can RBI's later clarification legalize an earlier transaction? No. Clarifications are prospective. Earlier contraventions remain punishable. 251. Is foreign exchange regulation considered part of national security? Yes. Courts linked FERA enforcement to economic and national security. 252. Can ignorance of RBI notifications be pleaded as defense? No. RBI notifications have statutory force. Persons are presumed to know the law. 253. Can an accused seek parity with another offender's lenient order? No automatic right. Each FERA case is decided on its own facts. 254. Does partial compliance reduce criminal liability? No. Partial compliance. Contravention remains complete. 255. Is ED bound by principles of natural justice under FERA? Yes. Notice and opportunity of hearing are mandatory. But scope is narrower than civil laws. 256. Can jurisdictional defects invalidate FERA proceedings? Yes. Lack of jurisdiction is a fatal defect. Can be raised at any stage. 257. Is settlement between private parties relevant in FERA cases? No. FERA offences are against the state, not private individuals. 258. Does confiscation require proof of ownership? No. Possession plus contravention is sufficient. Ownership disputes are secondary. 259. Can it rely solely on documentary evidence? Yes. Documentary and banking records are often sufficient proof. 260. What is the examiner's last resort MCQ trick on FERA? FERA being repealed, courts should apply liberal interpretation. 261. What is the safest 5-word mantra for FERA exams? Prohibit first, permit later. 262. What is the final relationship between FERA and FEMA? FERA, control, crime, deterrence. FEMA, management, compliance, facilitation under Foreign Exchange Management Act, 1999. 263. When can a student confidently eliminate options in FERA MCQs? Eliminate any option that suggests liberal interpretation, automatic regularization, absence of liability due to good faith. 264. What is the absolute final takeaway for law competitive exams? FERA is unforgiving, criminal, and permission-centric. Apply the strictest interpretation unless the statute expressly relaxes it. FERA, Foreign Exchange Regulation Act, 1973, FAQ Section 18. 265. Can principles of natural justice be excluded expressly under FERA? No. Unless expressly excluded, principles of natural justice apply. However, their scope is limited due to the nature of economic offences. 266. Is show cause notice mandatory before adjudication under FERA? Yes. Issue of show cause notice is mandatory. Absence of notice can invalidate adjudication. 267. Can ED rely on circumstantial evidence alone under FERA? Yes. Circumstantial evidence, banking trails, and documents can be sufficient if they establish contravention. 268. Does FERA recognize joint liability for collective decisions? Yes. Persons acting in concert can be held jointly liable. Common intention need not be proved expressly. 269. Can penalty proceedings continue if prosecution fails? Yes. Adjudication and prosecution are independent. Failure of one does not automatically defeat the other. 270. Is there any concept of compulsory mens rea under FERA? No. Mens rea is not compulsory. Statutory contravention itself constitutes the offence. 271. Can RBI delegate its powers under FERA to banks? Yes. Through authorized dealers, subject to RBI directions and supervision. 272. Can proceedings be initiated against legal heirs under FERA? Criminal prosecution abates on death. Penalty adjudication may continue against estate as per law. 273. Is standard of proof same in adjudication and prosecution? No. Adjudication, preponderance of probabilities. Prosecution, proof beyond reasonable doubt. 274. Can it reopen concluded adjudication under FERA? Generally no. Unless obtained by fraud, suppression, or lack of jurisdiction. 275. Are RBI permissions revocable under FERA? Yes. RBI may revoke or modify permission. Prospectively, not retrospectively. 276. Can foreign exchange laws be interpreted harmoniously with Customs Act? Yes. Courts apply harmonious construction. Each statute retains independent operation. 277. Does FERA allow mitigation based on economic conditions? No. Macroeconomic conditions do not excuse violations. Policy considerations are for legislature, not adjudicators. 278. Can it rely on presumptions under Evidence Act in FERA cases? Yes. Presumptions under Evidence Act can be applied, along with statutory presumptions under FERA. 279. Can accused challenge constitutionality of RBI directions? Yes, but only before constitutional courts, not before adjudicating authority. 280. What is the examiner's rarest but decisive FERA question? Whether repeal of FERA creates equity in favor of accused. Answer: no, repeal saves liabilities fully. 281. What is the safest elimination logic in ultra-hard FERA MCQs? Eliminate options suggesting liberal interpretation, automatic regularization, requirement of mens rea as essential. 282. What is the last three-word memory hook for FERA? Criminal, controlled, unforgiving. 283. How should FERA be contrasted in one breath with FEMA? FERA, control crime deterrence. FEMA, management compliance facilitation under Foreign Exchange Management Act, 1999. 284. What is the absolute final line to close FERA revision? FERA represents India's strict foreign exchange control era, where permission, not intention, decided legality. FERA, Foreign Exchange Regulation Act, 1973, FAQ Section 19. 285. Can an accused demand parity with FEMA compounding standards in FERA cases? No. FERA cases are governed strictly by FERA. FEMA's liberal compounding standards do not apply retrospectively. 286. Does subsequent RBI liberalization circular help old FERA violations? No. Liberalization is prospective only. Old violations remain punishable under FERA. 287. Can it proceed even if RBI does not file a complaint? Yes. It has independent statutory powers. RBI's role is regulatory, not prosecutorial. 288. Is mens re ever presumed conclusively under FERA? Mens re is not required to be proved. Liability arises from contravention itself, not intent. 289. Can delay caused by accused be used against him? Yes. Accused cannot take advantage of self-created delay. Frequently tested in judiciary exams. 290. Can foreign exchange seized be adjusted against penalty? Yes, in appropriate cases. Subject to adjudication order. No automatic right of adjustment. 291. Does confession alone suffice for conviction under FERA? Yes, if confession is voluntary, supported by surrounding circumstances. 292. Can penalty be imposed even if prosecution sanction is refused? Yes. Adjudication is independent of prosecution. Sanction is required only for criminal trial. 293. Is ignorance of authorized dealer rules a defense? No. Authorized dealer rules flow from RBI directions. Ignorance is not a defense. 294. Can it rely on presumptions without rebuttal evidence? Yes. Once statutory presumption applies. Burden shifts to accused to rebut. 295. What is the rarest examiner trap regarding repeal of FERA? Repeal means the offence itself disappears. Incorrect. Liability is expressly saved. 296. Can accused invoke Article 14 for discriminatory penalties? Only in extreme cases. Courts allow wide discretion in economic offences. Differential penalties alone discrimination. 297. Is FERA considered procedural or substantive law? Substantive penal law. Hence governed by strict construction. 298. Can it prosecute a company without prosecuting directors? Yes. Company has independent criminal liability. Directors may be prosecuted separately. 299. Does acquittal of directors automatically absolve company? No. Corporate liability is independent. 300. What is the final absolute MCQ mantra for FERA? If permission is doubtful, liability is certain. FERA, Foreign Exchange Regulation Act 1973, FAQ Section 20. 301. Can a person be prosecuted under FERA and IPC for the same act? Yes. If the act constitutes distinct offences under different laws, subject to protection against double punishment for the same offence. 302. Does FERA recognize the concept of continuing offence after repeal? Yes. If the offence continued during FERA's operation, liability survives. Repeal does not erase consequences of continuation. 303. Can it rely on electronic records in late-stage FERA cases? Yes. Subject to admissibility rules. Banking and documentary trails are sufficient even in legacy matters. 304. Is mens re completely excluded from all FERA provisions? Almost. For most contraventions, mens re is irrelevant. Only few provisions consider conduct for penalty discretion. 305. Can foreign exchange offences be settled privately after detection? No. Private settlement has no legal effect. FERA offences are against the state. 306. Does delay in adjudication violate Article 21 automatically? No. Only inordinate and prejudicial delay may invite relief. Mere passage of time is insufficient. 307. Can RBI issue retrospective permissions under FERA? No. Permissions are prospective. Retrospective validation is generally impermissible. 308. Are ED officers considered police officers under FERA? No. Hence, statements recorded by ED officers are admissible. Section 25 of Evidence Act does not apply. 309. Can a person claim vested right to compounding under FERA? No. Compounding is a statutory concession, not a right. 310. Can confiscated foreign exchange be returned after appeal? Yes. If appeal succeeds, subject to final judicial outcome. 311. Does FERA apply uniformly across India? Yes. FERA had pan-India application, including designated special areas. 312. Can it prosecute even after penalty is fully paid? Yes. Payment of penalty does not bar prosecution, unless specifically compounded. 313. Are RBI permissions transferable? No. Permissions are personal and conditional, non-transferable unless expressly allowed. 314. Does FERA recognize substantial compliance doctrine? No. Only strict compliance is recognized. 315. What is the examiner's most reliable elimination rule in FERA MCQs? Eliminate any option suggesting liberal interpretation, automatic regularization, mens rea as essential element. 316. Can it rely on presumptions even if evidence is circumstantial? Yes. Statutory presumptions plus circumstantial evidence. Shift burden to accused. 317. Does FERA distinguish between minor and major contraventions? No formal distinction. Severity reflected only in penalty quantum. 318. Can foreign exchange once repatriated later absolve offense? No. Subsequent compliance does not erase past violation. 319. What is the final safest assumption in any FERA problem question? If permission is missing, liability exists. 320. What is the final one-line closure of FERA jurisprudence? FERA criminalized control of foreign exchange to protect national economic interest, and its saved liabilities continue to operate despite repeal. FERA, Foreign Exchange Regulation Act 1973, FAQ Section 21. 321. Can it initiate FERA action based solely on audit or intelligence inputs? Yes. Audit objections, intelligence inputs, or bank reports can form reasonable belief. Must be backed by material, not mere suspicion. 322. Does FERA permit prosecution without prior adjudication? Yes. Adjudication is not a prerequisite for prosecution. Both remedies are independent. 323. Can accused seek cross-examination of bank officials in adjudication? Not an absolute right. Allowed only if necessary for fairness. 324. Is RBI's opinion binding on adjudicating authority under FERA? RBI opinion is highly persuasive. But adjudicating authority must apply independent mind. 325. Can it rely on foreign evidence or overseas bank records? Yes. Foreign records are admissible if legally obtained. Common in export, import and hawala cases. 326. Does FERA recognize beneficial ownership over legal ownership? Yes. Courts apply substance over form. Beneficial owner can be proceeded against. 327. Can penalty under FERA be imposed jointly and severally? Yes. Joint contraventions can attract joint and several liability. 328. Does acquittal on technical grounds bar fresh proceedings? Depends on facts. If acquittal is not on merits, fresh lawful action may lie. 329. Can it reopen investigation after closure report? Yes, if new material emerges. Earlier closure was not on merits. 330. Is economic offence treated differently from ordinary crime in FERA? Yes. Courts apply stricter standards. Greater emphasis on deterrence. 331. Can it rely on presumptions without producing original documents? Yes, if certified copies are produced. Originals are unavailable for valid reasons. 332. Does FERA permit attachment of property pending proceedings? Yes. Provisional attachment seizure allowed to secure penalty recovery. 333. Can an accused argue absence of gain as defense? No. Gain or loss is irrelevant. Contravention alone is sufficient. 334. Can FERA proceedings be quashed on grounds of settlement with co-accused? No. Private settlement has no effect on statutory liability. 335. Does payment of tax on foreign income cure FERA violation? No. Tax compliance, foreign exchange compliance. 336. Can it proceed if foreign exchange is routed through third country? Yes. Routing through intermediaries does not dilute liability. 337. Is reasonable cause a recognized statutory defense under FERA? Very limited recognition. Generally, strict liability prevails. 338. Can adjudicating authority enhance penalty suo motu on remand? Yes, provided opportunity of hearing is given. 339. Does repeal of FERA weaken evidentiary presumptions? No. Presumptions continue for saved proceedings. 340. What is the safest judicial presumption to apply in FERA questions? When statute is strict, courts will not dilute it by equity. 341. One-line judiciary answer for FERA versus FEMA. FERA, criminal, deterrent, permission-centric. FEMA, civil, facilitative, compliance-centric under Foreign Exchange Management Act, 1999. 342. Final memory lock for Section 21. FERA punishes the act, not the intent. FERA, Foreign Exchange Regulation Act, 1973, FAQ Section 22. 343. Can it initiate FERA proceedings on the basis of anonymous complaints? Yes, if the complaint is corroborated by independent material forming reasonable belief. Anonymous complaint alone is insufficient. 344. Does FERA permit clubbing of multiple transactions into one offence? Yes. Connected or continuing transactions may be clubbed. Helps determine gravity and penalty quantum. 345. Can accused demand supply of all relied upon documents? Yes. Relied upon documents must be supplied. Non-supply can vitiate adjudication for breach of natural justice. 346. Is cross-border electronic communication evidence acceptable in FERA cases? Yes. Emails, telex, SWIFT messages, bank advices are acceptable, subject to admissibility rules. 347. Can it proceed against dormant or struck-off companies under FERA? Yes. If offense occurred during existence, directors' officers can still be proceeded against. 348. Does FERA recognize constructive possession of foreign exchange? Yes. Physical possession not mandatory. Control or dominion is sufficient. 349. Can accused invoke proportionality to reduce mandatory penalties? Limited scope. Courts rarely interfere unless penalty is shockingly disproportionate. 350. Can RBI issue clarificatory circulars during pending proceedings? Yes. But such clarifications are prospective. They cannot legalize past contraventions. 351. Does acquittal due to benefit of doubt affect adjudication penalty? No. Adjudication and prosecution are independent. Penalty may survive despite criminal acquittal. 352. Can it rely on presumptions even if accused produces partial explanation? Yes. Incomplete or implausible explanation fails to rebut presumption. 353. Are foreign exchange transactions through relatives treated leniently? No. Routing through relatives is often treated as aggravating conduct. 351. Can limitation under CRPC be applied to FERA prosecutions? Generally no. FERA prescribes its own scheme. Economic offense nature justifies longer timelines. 355. Can accused seek compounding after appeal is dismissed? Only if statute authority permits. No vested right to compounding exists. 356. Does FERA allow enhancement of penalty at appellate stage? Yes. Appellate authority may enhance penalty. Opportunity of hearing is mandatory. 357. Can it proceed simultaneously under Customs Act and FERA for same facts? Yes. Different statutes, different objectives. Subject to protection against double punishment. 358. Does payment of customs duty or redemption fine absolve FERA offense? No. Compliance under one statute does not cure FERA contravention. 359. Can it rely on confessional statements retracted after long delay? Yes. Delayed retraction weakens credibility. Courts examine voluntariness. 360. What is the safest last-minute MCQ elimination rule, FERA? Eliminate any option suggesting liberal interpretation, automatic regularization, mens rea as essential element. 361. One-line final contrast for instant recall. FERA, criminal. Control, presumption of guilt. FEMA, civil. Management, compliance under Foreign Exchange Management Act, 1999. 362. Final ultra-short memory hook. FERA punished control breaches, not intentions. FERA, Foreign Exchange Regulation Act, 1973, FAQ Section 23. Ultra-advanced. Rare judicial angels, final examiner traps. 363. Can it rely on bank compliance failures to infer accused's liability under FERA? Yes. Failures by authorized dealers, banks, can corroborate contraventions. But primary liability must still be linked to the accused's acts omissions. 364. Does FERA recognize attempt as an offense even if transaction fails? Yes. Attempt to contravene is punishable. Completion of transaction is not mandatory. 365. Can penalty be imposed for mere possession of foreign exchange? Yes. Unauthorized possession itself constitutes contravention. Proof of use is unnecessary. 366. Is burden of proof static throughout FERA proceedings? No. Initial burden on ed to show contravention. Thereafter, burden shifts to the accused to prove legality. 367. Can it rely on presumptions even if accused remains silent? Yes. Silence does not rebut statutory presumptions. Accused must offer a plausible explanation. 368. Does FERA permit splitting of liability among co-accused? Liability may be individual or joint, depending on role. Penalty quantum can vary based on involvement. 369. Can it initiate proceedings based on foreign regulators' input? Yes. Inputs from foreign regulators' agencies can form reasonable belief. Must be supported by admissible material. 370. Does FERA recognize the defense of commercial expediency? No. Commercial necessity does not override statutory prohibition. 371. Can confiscation be ordered even when penalty is waived or reduced? Yes. Confiscation is independent of penalty quantum. Both can coexist. 372. Is proof of ownership necessary for confiscation under FERA? No. Possession control plus contravention is sufficient. 373. Can it proceed against guarantors or facilitators? Yes. Abettors, facilitators, and guarantors can be proceeded against. Active facilitation suffices. 374. Does FERA allow defense of industry practice? No. Prevailing practice cannot legalize illegality. 375. Can it rely on pattern of conduct evidence? Yes. Repeated similar transactions can establish systematic contravention. 376. Is mens re ever relevant at appellate stage? Not for determining liability. May be considered only for penalty mitigation, rarely. 377. Can adjudicating authority rely on RBI's expert view on technical matters? Yes. RBI's view is highly persuasive on forex compliance issues. 378. Does FERA recognize reasonable cause to drop proceedings? Very limited. Generally, strict liability prevails. 379. Can it proceed where foreign exchange is routed through layered entities? Yes. Layering does not dilute liability. Substance over form applies. 381. Final instant recall line, Section 23. Under FERA, control, not convenience, decides legality. 382. Final contrast for memory lock. FERA, criminal. Control, presumption of guilt. FEMA, civil. Management, compliance under Foreign Exchange Management Act, 1999. FERA, Foreign Exchange Regulation Act, 1973, FAQ Section 24. 383. Can it initiate FERA proceedings merely because FEMA is now in force? No. Proceedings must relate to acts committed during FERA's operation. FEMA's existence does not revive or dilute FERA liability. 384. Does repeal of FERA create a presumption in favor of the accused? No. Repeal is accompanied by a saving clause. No presumption or benefit flows to the accused. 385. Can accused seek application of beneficial interpretation due to passage of time? No. Time lapse alone does not soften FERA's rigor. Liability is judged as on the date of contravention. 386. Is it required to prove motive behind foreign exchange transactions? No. Motive is irrelevant. Proof of contravention is sufficient. 387. Can it rely on internal correspondence and internal notes of accused? Yes. Internal emails, letters, notes can establish knowledge and control. Frequently decisive in adjudication. 388. Can accused plead that transaction was revenue neutral to India? No. Revenue impact is irrelevant. FERA focuses on control and permission. 389. Does partial authorization legalize unauthorized excess? No. Authorization is strictly limited to its terms. Excess beyond permission is a separate contravention. 390. Can it proceed if foreign exchange was temporarily held and later surrendered? Yes. Temporary possession without permission is still an offense. Later surrender does not erase liability. 391. Can adjudicating authority rely on probabilities rather than direct proof? Yes. Preponderance of probabilities applies in adjudication. Direct proof is not mandatory. 392. Does acquittal under IPC affect FERA proceedings? No. IPC and FERA operate in different fields. Acquittal under IPC does not bar FERA action. 393. Can accused argue that law was unclear or ambiguous? Rarely accepted. FERA provisions are treated as clear and mandatory. Ambiguity, if any, is resolved in favor of control. 394. Can it rely on statements of co-accused? Yes. Statements of co-accused are admissible. Weight depends on corroboration. 395. Does FERA permit compounding after final conviction? Generally no. Compounding is pre-conviction and discretionary. No right after final adjudication. 396. Is business necessity a valid defense? No. Business necessity cannot override statutory prohibition. 397. Can it reopen a matter closed due to technical defect? Yes. If closure was not on merits. Fresh lawful proceedings may be initiated. 398. Does FERA recognize mitigation for first-time offenders? Only marginally. May influence penalty quantum, not liability. 399. What is the safest absolute rule to apply in any FERA problem? If RBI permission is not provable, contravention is established. 400. What is the final one-line doctrine of FERA? FERA criminalized foreign exchange control through strict permission-based compliance. Repeal did not erase its liabilities, only replaced its philosophy with management under Foreign Exchange Management Act 1999. FERA, Foreign Exchange Regulation Act 1973, FAQ Section 25. 401. Can it rely on indirect financial trails to establish FERA contravention? Yes. Indirect trails, layered accounts, routing through intermediaries are valid. Direct receipt payment need not always be proved. 402. Is proof of actual foreign exchange movement mandatory? No. Attempt, arrangement, or control over forex transaction is sufficient. Actual remittance is not compulsory. 403. Can accused argue absence of RBI guidelines at the relevant time? No. Statutory prohibition applies even without detailed guidelines. Guidelines clarify. They do not create legality. 404. Does FERA recognize defense of clerical or accounting error? Rarely. Minor error may affect penalty quantum. Does not negate contravention. 405. Can it rely on expert opinion, RBI forensic audit, as evidence? Yes. Expert opinion is admissible and persuasive, especially on technical forex compliance issues. 406. Can foreign exchange offences be inferred from unexplained assets? Yes. Unexplained foreign assets or balances raise statutory presumptions. Burden shifts to accused. 407. Is good corporate governance a defense under FERA? No. Corporate policies cannot override statutory obligations. 408. Can it proceed where transaction was lawful abroad but illegal in India? Yes. Indian law prevails for persons subject to FERA.